this beautiful panel, truly international panel with people really from across the globe. I'm currently located in the southern tip of Sweden. It's a little bit dark, cold, grey, boring, and a lot of COVID around. So everything is just troubled. Would love to be in Italy this spring, but unfortunately not. This is how it works. So really, really difficult. My name is Andreas Inghammar. I work at the business law department of the business school at Lund University in Sweden. Our team for this panel, this session, is, as I said, very international. We will start with Federico Fusco of Prince Mohammad bin Fahd University of Saudi Arabia. Federico has a recent background in Sweden at Lund University, but also a background in Napoli in Italy. We will then move from Saudi Arabia to Hong Kong, where we will meet Julia Tomassetti with an American background, but ending up in Hong Kong at the present. Then we'll move back to Europe to Harry Stylogiannis from the Katholieke Universiteit Leuven. And then we will open up for questions or comments on this topic later on. Hopefully we can meet the deadline of 10 minutes for each presentation and have plenty of room for comments and questions later on. You can post your questions in the chat room, or I think we are quite a few people, so probably might be better if you post your questions in the chat room and we will deal with them as they arrive here. Great. So if there are no questions or no problems, technical problems with anything, apart from traveling to Italy, I will leave the floor to Federico, please.
Thank you, Andreas. Well, good afternoon or morning or night to everybody. I don't know, I think we are in a pretty different geographical area and different time zone, but it's a pleasure to be here and to keep this conference going and to meet you even if virtually. Well, will not add anything to what Andreas said about my introduction, so thank you. I will jump to discuss my topic. In the next 10 minutes, of course, I will not have the time to discuss all of my research, so I will try to give you the most important points. Teaching, and every semester when I start the course of labor law, I always struggle with the same problem, literally. Speaking about labor law, I should explain to the students not only what labor law is, but also to whom we should apply labor law, which is the border of labor law. Yes, people performing some economic activity, but then also someone raising the hand, doctor, but in this case it has a scenario and so on. What I'm trying to say is that it is not a new topic, but in mostly with the digital economy, a big issue is to understand where is the border of labor law. How should we allocate labor protection? How should we decide which people are included under the shelter, the umbrella of labor law, and which people are not? And it seems to me that, of course, there is a lot of debate, a lot of case law, a lot of books, paper, and so on. But it seems to me that nowadays we are at an important moment, a moment in which we really should stop and understand if we can keep applying the same way of reasoning that more or less we had in the last 100 years. So give labor law protection on the ground of an idea of subordination based on the organization, how the activity is organized, or if we should shift into the direction of a notion of subordination based more on the economic reality or on the economic weakness of the person performing the activity. So this is the core of my research, and I will try now to point out something. Well, first of all, I'm sorry, but I don't have the definite answer. I hope you will forgive me for this. So I will mostly try to ask questions and to highlight some points. I've also been pretty lucky because in the last month we had some new things that happened concerning to this topic. I mostly speaking about the gig economy, as I believe most of you will know, the UK Supreme Court roughly 1 month ago issued a very important decision concerning the status of the Uber drivers in UK. Other decisions are in the court of all over the world, but I am Italian, so another relevant element is that the Italian Labor Inspection Authority a few weeks ago just kind of concluded a big check on several companies that perform food delivery at home, and they applied, they say that those people are not really self-employed, but fall within a middle category. This element of the middle category, I think, is pretty important, because if we look at several jurisdictions around the world, this is a little bit the solution that we have in place in many countries, both in common law legal framework and in civil law legal framework. We have the trend of the labor law to expand its area of influence and giving some of its protection also to people that are not really employees, but they are economically weak. So this is not really something new. It happens since a very long time. What I'm trying to do with my paper and my research is try to identify a little bit which are the latest trends and maybe some hint of how we should continue. However, under a comparative perspective, we should be aware that speaking about the middle categories is not enough, because even if it is true that many jurisdictions have some type of middle category, it is also true that the legal effect of placing some people performing economic activity in the middle category can have different legal outcomes. So, for example, if we speak about the category of worker, like in UK, they get some of the protections of the employee, but not all of them. On the other hand, in Italy, with the so-called hetero-organized cooperation, the law says that it gets applied all the entire set of rules typical of the employment. So the consequence can be different. And of course, also in Italy, there is discussion if we can really apply everything or not. But we still look at this trend. What I think it is interesting to notice is that also under a policy perspective, we are now in a situation in which gig companies of the gig economy, so platforms, like, just to name some, Uber, Deliveroo, and so on, are a little bit going out of the gray area. What do I mean when I speak about gray area? When they started their operation, let's say Uber, they were acting in an area that, because it was new, seemed to be outside of many regulation. So not only for under the employment perspective, but there has been issue with tax law. For example, in Sweden, there have been issues with license for cabs in many jurisdictions. Now this situation is going to an end. We see that in different number of jurisdictions, at least under the labor perspective, there are some laws that apply. Thus, it is also interesting to see that, for example, Uber in Canada last week was wishing and saying, let's regulate and give some protection to, let's have some law giving some protection to the drivers. One of the managers of Uber in Europe, after the decision of UK, also was wishing that for the well-being of the drivers, also other companies in the same market, so basically the competitors, would have start to apply some protections. Or what else? Deliveroo in Italy recently created a fund, they call it a thank you fund, to compensate some of the drivers. So it seems to me that it is out of question the fact that we are facing some type of regulation under maybe not really employment law, but giving some of the protection of the employment law. Where the difference really is how legal frameworks are creating this type of protection. For example, in Italy, we still are linked to the idea of subordination that looks at the organization. So the law doesn't really speak about economic weakness, but how the activity is organized. While in other jurisdictions, for example, in France, but also in Germany, if not wrong, the law looks a little bit more to the economic side. So what I really think it is important now to point out, and with this I think I should start to conclude, to stay within the 10 minutes, right, Andreas? Yes, more or less. Is that we need to decide if we should keep enlarging the notion of subordination under an organizational perspective, or we should slowly shift into the direction of a notion of subordination based more on the economic activity. Or, sorry, not on the economic activity, but on the economic weakness. I personally think that this latter option would be the best, because it will look at the essence of the problem. The fact that there are people performing an activity that are economically weak. Otherwise, the risk is to repeat somehow what it happened in UK with Deliveroo, when a court said that a rider was a worker because there was no power of substitution. After a few weeks, the platform changed the contract, introduced the power of substitution to the contract, and the new decision said you are not a worker because we have the power substitution. So I think that will be good to focus and better more on the economic element and economic weakness. Of course, this, and this is really the last thing that I say, of course, this is not going to eliminate all the problems because still there will be a border. And every time that we have a border, it's not super easy to understand and define how to regulate a situation which is close to the border. But maybe to have an approach that will give an increasing or decreasing amount of right, looking how strong or how weak someone is, it could be maybe a solution, make the situation a little bit easier to handle. This is in brief my research, and I will be very happy to answer any question later if you have and to give your comment. And thank you very much.
Thank you so much, Federico. I think you're touching upon some really important issues with the economic dependency and economic weakness. And how that could possibly be regulated and how that could be addressed is hopefully for the future questions or comments or suggestions by the audience, also to suggest us very strong solutions to these issues and how to refocus from how we organize work to the economic or weaknesses or dependencies of these. If there are any direct questions, I think we can pop in one or two of them. Otherwise, I think I don't see any in the chat room. So no. So then I think we should spare the questions or comments for later and move on to Julia, who will explore the comments or the discussion based on previous experience, long-term experiences of FedEx. Are you there, Julia?
Okay.
Perfect. Thank you very much.
Great. I hope everybody can hear me. Yes. So I'd like to introduce some very preliminary findings that I'm not entirely sure how to interpret yet from a project on legal disputes that preceded the platform economy, but I think still shed light on the ways in which we perceive work in the platform economy. So this project looks at how pickup and delivery company FedEx, and along with its predecessor, Roadway, for decades in the US, experimented in the courts and before the US National Labor Relations Board with the legal distinction between independent contracting and employment. So FedEx's predecessor began competing in the 1980s with what was then the only major parcel delivery company in the US, which was UPS. Now, although its services that it offered customers were quite similar, it differed by purporting to hire its delivery drivers as independent contractors rather than employees. And that was where it saw its competitive advantage, UPS. Now, so for this part of the project, I'm focusing just on the company's cases before the National Labor Relations Board and the courts that reviewed board decisions. Now, there's several of these between the 1980s through around 2014, because each time delivery drivers would try to unionize, the company would contest the unionization on the basis that the delivery drivers didn't have rights to organize and collectively bargain under the National Labor Relations Act because they were independent contractors. Now, with each adverse decision, adverse to the company by the board, the company would modify its work arrangements in some ways to track indications or intimations in the decisions about what would make the work relationship more like independent contracting. And then it would reappear before the tribunal and again argue that the delivery drivers were independent contractors. So I like this example because it's one company for several decades that's providing essentially the same service to customers over this time, a highly rationalized service that involves a complex division of labor. subject to the same unchanging legal standard over these decades, and yet trying to shape notions of, I would say, employment and entrepreneurship through minor changes in its work relationships. So I'm going to provide a few examples here. So in a 1988 case, a panel of Reagan appointees on the board argued that, or decided that the delivery drivers were employees, not independent contractors, noting drivers bear few of the risks and enjoy little of the opportunities for gain associated with an entrepreneurial enterprise. Although drivers are responsible for various vehicle-related costs because they were responsible for leasing or purchasing their delivery vans, the board notes the employer establishes and regulates most matters essential to the driver's livelihood. The board focused on certain factors that factors bearing on the driver's inability to shape their costs or revenue in any substantial way. So the board notes, for instance, the employer controls the number of packages and stops, assignment of service areas, cost of service, meaning it was the company and not the drivers who decided how much customers would pay for delivery, and compensation. The board also noted that the drivers did not have a proprietary interest in their routes, and we'll come back to that later. And the board noted that the company, through various ways, minimized the risk of loss that the drivers face. So for instance, by providing a startup loan program that would guarantee them a certain income per week, and even releasing drivers from vehicle payments when they were leaving the company. And the board also argued that there's certain ways that the company controlled their work that was inconsistent with their being independent contractors. So they had to work 5 days a week, and they had to pick up and deliver all the assigned packages, coordinating their schedules, well, under the company's supervision, coordinating their schedules according to the line haul drivers, or when the packages would arrive at the terminals, and customer windows. They had to wear uniforms, and they had to comply with various company rules, often company rules like completing paperwork that were meant to service the pickup and delivery customers. The fact that the board noted that, okay, so drivers are permitted to use substitutes, and they could even hire people to help them. This did not make them independent contractors. So that's one decision. The next year, 1989, another board panel, this time all Republicans, found that the drivers were again employees and not independent contractors, emphasizing that the drivers perform functions that are an essential part of the company's business, that they did business only in the company's name, under its supervisors, and sold only its services. And again, they noted that the drivers had no proprietary interests in their routes. Now, the board hears yet another challenge by the company to the employment status of its drivers seeking to unionize in 1998. This time, about 10 years later, the company emphasizes that it's made several changes to its operations that should change the board's legal conclusions. Now, it doesn't change the board's legal conclusions, and the board still finds that the drivers are employees. What the company argued, however, was that the drivers now had a proprietary interest in their routes. So what did this mean? How did they own their delivery routes? Well, the company claimed drivers could now sell their routes. On the other hand, they could only sell it to basically another driver, somebody acceptable to the company. And despite this purported ownership rights, the company could take away the route or parts of a driver's route on 5 days' notice. So this might generally happen, for instance, if the number of pickups and deliveries on a certain route became too much for a driver to handle, so they wants to reconfigure the service area. They tell the driver you have 5 days to sell, or in essence, you accept the pay cut associated with a smaller service area. So the board found, given this situation. Yes.
Can I just ask you, are you changing the slides, or is it just the one slide?
Oh, no, just one slide. Just one slide.
Thank you very much.
Okay. So the board finds that there's really no market for the routes, and any sales in the record were under a threat of termination or reconfiguration by the company. So this proprietary interest, and this is my characterization, is you can think of it more like the possibility of getting a severance upon leaving work. The board also the same factors it had before that demonstrated the drivers weren't operating independent businesses, but were part of the company's pickup and delivery business. For instance, noting they devote a substantial amount of their time, labor, and equipment to performing essential functions that allow Roadway to compete in the small package delivery market. They noted also that, quote, the driver's connection to and integration in Roadway's operations is highly visible and well publicized. And however, the board here also lists a few things that it thought would suggest that the drivers had entrepreneurial opportunity, such as their incorporation as businesses and the use of additional drivers or helpers. All right, so, and here's where things start to change. In 2006, 2007, there's another challenge. The board finds that the drivers are still employees, but this time FedEx takes the board's decision to a federal appellate court, and in 2009 the court finds that the drivers are independent contractors. Now there's two notable things about this decision, about this decision. First, now we see that the company has been successful in trying to track some of the board's previous suggestions, even if they weren't meant as suggestions, about what changes it could make to its work relationships to change the legal outcome. So for instance, they had transferred more of the risk to drivers. They didn't necessarily release drivers from vehicle payments when they left the company anymore, even though they did generally find a new driver to take over the truck. Now FedEx did either encourage or at this point I think encourage drivers to incorporate themselves. But in addition to tracking some of these suggestions, we also see here a different interpretation of what it means to be an independent contractor that I think more drives the court's outcome. So the court was that the drivers were entrepreneurs because of the fact that they could, in theory, sell their routes, meaning they could, in theory, sell their jobs. Now, of course, drivers were not in the business of buying and selling jobs, but this was enough for the court. So I'd like to point out a similarity here to the argument that platform companies often make, companies providing on-demand services, that by deciding if and when to work, logging into the app, oh, sorry, that was my timer, I'll wind up now. Platform workers were exercising entrepreneurial opportunity. So this somewhat echoes the argument of the court in FedEx that by deciding whether to have a FedEx job or sell it, one was exercising entrepreneurial discretion. And it's similar to the argument that platform companies make that the control to which a worker is subject while logged in is not as relevant to, not all that relevant to her employment status because she doesn't have to log in and chooses when to work. So similarly, FedEx argues that, well, drivers can always hire substitutes, basically hire their coworkers and then share the income, their income with them, so they don't ever actually have to work. Now, I would say that what we see here is a point that Tommaso Fabri brought up at the opening speech, that we see this conflation of discretion and autonomy. So we don't, drivers have some discretion here, but not what you would call business autonomy. We also see a reinterpretation of entrepreneurial activity. So we're no longer focused on successful product market competition or how production is organized. Rather, we see any contracting rights, even when it's not in the context of commerce or even in a market, as an indication of entrepreneurial opportunity. So hiring a coworker to substitute for you. Every contract, no matter whether its institutional context is within a bureaucracy or a market, is a calculated allocation of risk and reward and therefore appears entrepreneurial. To the extent there is some focus on product market competition, the kind that is valorized also differs here between the court and the board. The board didn't find the formal right to hire replacements or substitutes to be dispositive positive. But here the court finds that the ability to exploit the labor of others, even if you're not realizing any other productive efficiencies, made the drivers entrepreneurs. Again, I think conflating business autonomy and discretion. And finally, and I'll end here, in contrast to the board, found that any exercise of control over drivers or a deprivation of entrepreneurial opportunity that would be necessary to service its customers was not really evidence of employment. And here again, we see the court prefiguring arguments commonly made by platform companies. To quote, FedEx is an intermediary between a diffuse groups of senders and a broadly diverse group of recipients. With this model come certain customer demands, including safety. So and the court continues, a uniform requirement, often at least in part, is intended to ensure customer security rather than to control the driver. And once a driver wears FedEx's logo, FedEx has an interest in making sure her conduct reflects favorably on that logo. So, all right, again, very similar to the argument that platform companies make. And to conclude, and I promise I'm concluding now, so what I've seen so far is that we do see the company making changes to, in some ways, try to track the adverse legal decisions against it while not changing its service and still using uniform delivery drivers 5 days a week who work all day and must perform all assigned work. Now, despite these modifications as well, we don't see it affecting the legal outcome until this 2009 case by the Court of Appeal, where they also adopt, it's not just that the company has made some changes, but you see the board also interpreting what it means to be an entrepreneur or an independent contractor quite differently. And that's where I'll end. Thank you.
Thank you so much. I think it touches upon a number of things, and the question of are we freaking out now because we have these new platform or gig platforms to address, or can we go back and see what has been previously addressed or handled in other forms long before the platform economy, in other forms of the labor market, other places of the labor market. I think that's quite interesting to do that. Perhaps we don't need to always look for brand new solutions for everything just because the technology changes. Yes, we will move on, and now we have a very interesting paper written by Harry. Hello, and Harry is not only a doctoral student at the Katholieke Universiteit Leuven, he's also a prize-winning author since last year, right? And so we have very high hopes for any prizes coming your way this year or any year in the future. But this is a very interesting paper and touching upon or exploring the human rights-based approach to labor law in this work. Please, Harry.
Thank you very much for your kind words. Good afternoon, everybody. I'm very pleased to be here next to distinguished colleagues and academics. Before I start with my presentation, I would like to say a big thank you to my two supervisors, Professor Valerio Di Stefano and Professor Frank Hendricks, for their unconditional support and also their comments on the paper. I don't have the slides. I uploaded the slides of my presentation, but I cannot see them on the screen. Okay, that's perfect. Let me see if I can control them. I can control it. Okay, as you can see for the title of my paper, this is the freedom of association and collective. Okay, I will have to go back. This is the freedom of association and collective bargaining in the platform economy, a human rights-based approach and an ever-increasing mobilization of workers. Here you can see the structure of today's presentation. To begin with, it can be argued that, as we know, the ever-increasing spread of non-standard forms of employment, including many platform workers, has caused many problems in relation to the labor protection of such workers. The majority, or a big number at least of them, are considered as self-employed, even though the real nature of the job may indicate and disguised employment relationship, which is often concealed behind the facade of organizational and economic independence. So we have a situation that platform workers often remain in a gray legal zone between traditional employment and self-employment, in which the scope of labor protection, as we know, is traditionally limited to the bare minimum. As a result, these types of workers are facing serious limitations towards the enjoyment of their fundamental labor rights, which importantly have been recognized as human rights by international human rights treaties. And I'm also referring to the rights of freedom of association and collective bargaining. More specifically, platform workers, they face obstacles due to the existing limitations of the labor law framework, where labor protections are still concentrated in standard employment relationships, as well as the conflict of labor law, with other areas of law, such as competition law. This is, for instance, due to the existence of strict antitrust laws, which consider self-employed workers as undertakings, and as a result, collective agreements can be in breach of a competition law. Restrictions for these types of workers can be also practical. For instance, the existence of fissured workplaces or difficulties in identifying the precise bargaining counterpart can restrict workers to freely enjoy their collective rights, the fundamental collective rights. So the question that arises is how this gap of labor protection can be bridged. Of course, there are also other solutions, but here I'm dealing with a human rights-based approach, and as to why such an approach it's important. As a matter of definition, a human rights-based approach identifies workers, regardless of their employment status, as rights holders who are entitled to rights that are derived from international human rights treaties and labor law treaties. Firstly, its importance lies on the inalienable nature of human rights that can create obligations that pervade the employment relationship. This is to say that international human rights law, as well as treaties, place the state as a principal duty bearer that, when necessary, should be taking the appropriate measures in order to fulfill and protect fundamental human rights. This can occur, for instance, through the enactment of relevant legislation, which complies with international standards. Secondly, a human rights-based approach can assist us in terms of legal coherence. We observe that there is a general inconsistency, despite the really positive decision in Uber lately, from the Supreme Court in the UK. There is a general inconsistency of national courts in adopting and applying criteria to establish the existence of an employment relationship. In many instances, the current tests on the determination of employment status fail to take under consideration novel aspects of work, for instance, via the digitalization of work. Only recently, of course, some courts have started to realize how technology and artificial intelligence can enable platform businesses to change the manner that traditional control by employers is exercised in a manner that it allows these platforms to enhance the overall control over their workers' activities, for instance, via the use of digital surveillance. As a result of all these decisions, we have different outcomes. Importantly, even in the same national legal context, even though, despite the fact that the working conditions of many of these workers working for these platforms can be similar. Thirdly, a human rights-based approach can be beneficial in relation to managerial prerogatives, which are the result of social and economic phenomena, such as the inequality of bargaining power and who owns the means of production. Workers in atypical arrangements, including many platform workers, share many of the characteristics, as we know, of typical employment relationships. However, within atypical work arrangements, the managerial prerogatives can be further magnified for a number of reasons. One of these reasons can be that these types of workers, they have less chances to unionize, or they are less hesitant to exercise their rights because they are afraid that their contract will be terminated. Therefore, this situation can lead to inferior working conditions, and as I'm arguing, a human rights-based approach can help us to balance this asymmetry of powers between the parties. In relation to the legal basis of this approach, just a simple scrutiny of positive law, international level, national level as well, suffices to realize that a considerable number of labor rights, such as the right to collective bargaining and the right to freedom of association, have been now included in a number of international, regional human rights treaties around the world, and they have been recognized as human rights by also several international national courts, as I said. Moreover, the universality of such rights and their applicability regardless of worker status has been also espoused by other international bodies, such as the International Labour Organization. And to move on, excuse me, okay. So also, it's really important to point out here that under international law and the verdict of many supervisory bodies, especially within the Council of Europe, such as the European Committee of Social Rights, as well as the ILO, there should not be a divergent treatment between employment and self-employment when it comes to the enjoyment of the rights to freedom of association and collective bargaining. In other words, the protection of these rights should not be only confined to the realm of an employment relationship. And this is really important. It's really important because such rights in the hands of workers, are really important in general to tackle future, present and future challenges. For instance, as a recent last year's OECD report points out, collective bargaining can result in a higher quality of the working environment in many areas, such as in the area of health and safety, or is associated with lower events of discrimination. Importantly, as the same report points out, and of course further literature that I'm referring in the paper, collective bargaining has a key role to play in modern workplaces and the introduction of new technologies. New technological developments, such as algorithmic control, for instance, if are not properly regulated and used, can result in the deterioration of working conditions, along with other restrictions in the enjoyment of worker rights, fundamental human rights, such as, for instance, the right to privacy. It makes no surprise, I think everybody agrees, that platform work constitutes a prominent example of this development and challenges. For instance, digital reputation systems are many times associated with incidences of discrimination. Now moving past to the collective responses within non-standard forms of employment and platform workers specifically, it has been observed that the stance of trade unions in relation to these types of precarious work has not been uncontroversial. For a long time, it has been argued that trade unions were often excluding the so-called outsiders, namely workers with insecure, precarious, low-paid jobs. That this can be linked to the fact that the industrial systems were created under a Fordist model of production, which had as prominent characteristics a relatively homogeneous group of potential members, mainly males, working full-time in relatively secure occupations. At the same time, workers in atypical jobs, they also felt that many times their interests, they cannot be represented through traditional unions. However, this seems to start changing. Trade unions have progressively come to realize that the increase of non-standard forms of employment would weaken their own capacity to act if they are not successful in including such worker in the membership. There is now a wide variety of strategies developed by traditional trade unions in order to engage with workers in non-standard forms of employment, including self-employed workers. And such, for instance, these strategies include the conclusion of collective agreements, or social dialogue and campaigning, or even helping workers in their litigation in the courts. Many examples of unions trying to include atypical workers in their activities we have in Germany, we have in the Netherlands, and in many other European and not only countries. Moving specifically to platform workers, this vivid interest that I just described from institutional unions towards atypical workers, it is also observed in relation to platform workers. Again, now lately we have more and more collective agreements that they also capture platform workers, or they concluded specifically for platform workers. For instance, the collective agreement in Denmark. We also have collective agreements outside Europe, in Australia, for instance, and unions, on top of the conclusion of collective agreements, they have also diversified their strategies in order to extend the reach to platform workers. This means that in many instances, for instance, they've created online forums where workers can meet online, as we do now, and organize their future actions, and also discuss about the problems. So this brings workers together. And at the same time, what is striking is the fact that even in situations that trade unions, traditional trade unions, have not been as proactive, or the representation of such worker is considered simply impractical, there is an increased number of non-traditional organizations that represent platform workers' collective interests. There are many examples in the UK, in the US, in Italy as well. Such unions have used their resources and political power, political influence, excuse me, I'm not sure about power, but the influence, to lobby for several pieces of legislation and proposals that they are designed to ameliorate the working conditions of platform workers. A prominent example, for instance, that I found in literature is the example of the US rideshare drivers United Los Angeles, an independent union that lobbied for the adoption of the AB5 law, as its members met many times with state legislators and to push forward the bill. Of course, now the bill does not capture gig workers anymore because of the referendum and Proposition 22, but still we see how independent union tries to influence public policy. What's more, in some instances, we also have the cooperation between non-traditional organizations like grassroots unions with traditional trade unions. We saw, for instance, this cooperation in the conclusion of the territorial collective agreement in a few kilometers away from Modena in Bologna. So we see also this cooperation. To conclude, in my article, I try to show that a possible way forward in order to bridge a gap of labor protection in relation to workers in non-standard forms of employment, including many platform workers, is the adoption of a human rights-based approach. We should not reinvent the wheel. The legal basis is already there and can be found under international law and the recognition of fundamental labor rights, such as the right to collective bargaining and to freely associate, as human rights, that they should be applicable, they should be universal, and regardless the labor status of workers. These specific rights, as I noted earlier, are of paramount importance in order to tackle future, again, present and future challenges, and especially to tackle the issues that are inextricably linked with new technological developments. The human rights rhetoric has been espoused by many unions in order to assist the workers in atypical work arrangements, The same can be said also for platform workers, where we observe an ever-increasing mobilization of workers, both in institutional trade unions and not traditional trade unions organization. So also we can say that this is an indication of a solidarity unionism, and as some authors arguing, a message that the labor movement tries to remain strong and of course adapt in the new world of work. Thank you very much for your attention. I will put the last slides to thank you. Okay, thank you.
Thank you very much. I think this is a very interesting topic to start with, and I just if you have any questions, please add them in the chat room. I've got one, but the still room, we have a couple of minutes more. I would like to start with you, Harry, with a comment. When I read your paper, immediately there was this, this reluctance or all these problems of how to organize, when to organize, if the trade unions do not accept the independent contractors as members. How could we do this? Would that dilute the idea of human rights-based approach for the collective rights, really? And I guess I was coming from this well-organized, structured Swedish labor market with very strong unions, but also very strong attitudes towards who are included, who are not included in those strong unions. To some extent, I think it comes with the benefits of a very strong union is that they can be very forceful and aggressively pursuing their ideas. The downside might be that they have to, have pretty strict borders. So in my head, I just started to think about this, and you don't touch upon that in your paper, but about other human rights-based perspectives on labor, such as child labor. Nobody would object and say, sorry, there is no problem. There is a lot of technical problems with child labor. So if you have a self-contracting child, that would be perfectly okay, right? My thoughts were a little bit like that. Can we also include other of these fundamental rights, such as child labor, and say, obviously this is a human right. You can't just self-employ a child, and that would be fine. And you can kind of move that perspective also to these collective rights, which might be a little bit more technically problematic to enforce, really. What do you say? Am I totally?
I guess you're right, and I think as long as there is a consensus in the international level about the nature of some rights, because collective bargaining and freedom of association has to be a consensus for these rights to be considered human rights, but they are not the only rights. Of course, there is also the right to discrimination. As you said, it's also related to child labor. So, of course, I think you can expand this approach in order to touch upon other rights as well. Just in my paper, I also chose to refer to these rights because, besides of rights per se, there are also enabling rights. Because as we see, for instance, collective bargaining can be really important also in relation to discrimination incidences in the workplace. So that's why I also chose to touch upon such rights.
I don't argue with that choice. I think it's an excellent choice. But if it somehow dies on the altar of technical problems with enforcement of collective rights, perhaps there could be a tool to open another door. Look at these rights, relate to other things, such as child labor, can be an eye opener for future discussions. Really, we have a question. Yeah, we have a question from for Federico in the chat room. Do we still need the concept of subordination? Why is it does not make more sense to distinguish independent from dependent work and only focus labor rights on the dependence perspectives? What do you say, Federico? Do we still need the concept of subordination, and what does it even mean in these new days?
Okay, first of all, thank you, Professor Hendricks. I totally agree with you. And let me say also that, I really love your paper from the new wow to the new how that I used a lot to prepare this speech. No, I probably have been it's my fault. I made some mistake and not be clear. So when I speak about economic subordination instead of organization subordination, maybe I have been using a terminology that is not appropriate. Probably is what you say, economic dependency, what we should really look to. So yes. Then also about the one size fits all, maybe I was a little bit fast on this. I mentioned it in the beginning. So right, let's try to, I agree also on this. We cannot have like the slot machine jackpot. Either you get everything or lose everything. The point, the goal, I think it should be to give different level of protection according to how much dependent someone is. Which criteria to use to go to the question of Professor Chesalina, if I pronounce it correctly. Yeah, $1 million question. When in the beginning I say that I don't have all the answer, that's exactly what I meant. Every time that we have a category and we have a border, it will always be tricky, I think, to identify the border in a sharp way. But on the other hand, we have been dealing with subordination for so many years now, and still we don't know exactly where is the border. This border has been moving. So I hope you will excuse a little bit of uncertainty, at least now that we are discussing, to go to this economic weakness. To try to answer a little bit, well, maybe there are some economic marker that we could use, like to define a level of income on under considering all the year, or checking if the person performing the activity is contracting only with one company, that of course can decide to cut the contractual relationship and leave the person without any income or not, or maybe a mix of those criteria. To give a unique answer is not easy, also because also for the subordination, different jurisdiction, the notion is a little bit different, right? Every country has a different approach. Probably, and with this I reconnect probably a bit also to what Harry was saying, involving trade unions and some kind of collective agreement and so on could help. I think that under this perspective, some kind of a self-regulation or giving power to the social party can help to really identify which are their needs. I know that the answer is not complete, and I apologize, but it's something I'm still reasoning on it, and every comment is really welcome because it will be super useful. Thank you.
Okay, thank you very much, everybody. We did discuss the other day, because we had this pre-meeting with the panel, how the FedEx perspective would fit into franchise concepts or other previously known concepts in the history. Really, would it make sense for the future to revisit some of these old cases that has been addressing franchise issues, for instance, in the background? Do you have anything to add in 1 minute or even 35 seconds, Julia, on this, or anything?
Probably not, but well, the franchise issue raises a good point in that we have to, of course, beware of labels. Like, we think we know what a franchise is, but the courts and the board also thought they knew what a proprietary interest was in a delivery route. And second, I think it raises the interesting question of whether, even if you have your own employees as a franchise, perhaps you are being squeezed much in the manner of an employee as well, if the principal company is really dictating most of the commercial requirements of your position.
Yeah.
That's it.
I guess you can be highly dependent on the main brand of the company. Okay, I think we are really on time. It's 4 o'clock sharp. And thank you very much to the panelists. Thank you very much to everybody who was listening. And thank you to the organizers who let us have this session today. I learned a lot from the discussions with the colleagues, and I learned a lot from reading the paper from Harry as well. Thank you so much. And have a good day. And let's move on, 4 o'clock sharp, to the next session.